What will happen to Lungu's eligibility case in the Constitutional Court? The matter of President Lungu's eligibility to stand for re-election in 2021 comes up for ruling in the Constitutional Court on 7th December 2018. On one side, you have those who argue that the two-term limit in the Constitution disqualifies Mr. Lungu from standing again. Since the return to multi-partyism, Zambia has had a two-term limit for the position of president. And on the other hand, you have Lungu's supporters who hold that there's a provision in the Constitution as amended in 2016 which allows him to recontest. While the amended Constitution maintains the two-term limit, it goes further to define a term as lasting at least 3 years. In Lungu's first term, he held office for less than 2 years. So, Clause 2 under Article 35 of the 1996 Constitution read, "Notwithstanding anything contrary contained in this Constitution or any other law, no person who has twice been elected as president shall be eligible for re-election to that office." Then Clause 3 of Article 106 of the 2016 Constitution reads, "A person who twice held office as president is not eligible for election as president." Now, from just reading these two clauses, one from the 1996 Constitution under which Lungu was first elected, and the second one from the 2016 amended Constitution under which he was re-elected, why the confusion? Well, Section 5 of Article 106 of the 2016 Constitution is the source of the confusion. It prescribes what must happen when a vacancy arises in the office of the president. According to this section, when a president vacates office due to death or by resignation, the vice president immediately assumes office and serves for the remainder of the unexpired term, no election. But if the vice president cannot assume office, then the Speaker of the National Assembly shall perform executive functions and call for election within 60 days. So the process prescribed in that section was not followed after the death of our former president Michael Sata. While the vice president Guy Scott did take over, he did not rule for the remainder of the term. That was the law at the time. Now, Section 6 of the same Article 106 states that a person who assumes office after the death of a president following the process prescribed in Section 5 above will not be deemed to have served a full term if less than 3 years remain to the time of the next election. Those in support of Lungu's eligibility argue that this must apply to him as well. Since the two sides could not agree, the matter was taken before the Constitutional Court for determination. Article 267 of the Constitution instructs the Constitutional Court to interpret the Constitution in line with the Bill of Rights in a manner that promotes its purposes, values, and principles. There are two ways the above constitutional provisions could be read. First, by considering the ordinary or literal meaning of the words, but staying mindful that those words or provisions are not read in isolation. So, reading Article 106.3, a person who has twice held office as president is not eligible for election as president. The literal meaning is Lungu is not eligible to stand. On the other hand, reading 106.6b, for purposes of Clause 106.3, a president-elect who serves for the unexpired term shall be deemed to not have served a term as president if less than 3 years remain before the date of the next election. The literal meaning is Lungu's first term is not deemed as a term. Now remember, these provisions are not meant to be read in isolation. So if Article 106 follows after satisfying Article 105, the definition of term may not apply to someone who does not satisfy the process prescribed in 105. Since they didn't in Lungu's case, the court may now have to look at the purposive meaning of the words. The court will try to establish what the framers of the law sought to achieve with those provisions. So in following the judgment, remember the two ways the provisions could be read. Ordinary or literal meaning of words, this is applied first. If that leads to absurdity, the court will follow the purposive approach to determine what the legislature intended. Like, comment, subscribe.